Harry Hedges. Harry Hedges, are you there? Can you hear? Hey, Lisa,
Yes.
is that going to happen with the link I send out that you sent for next week's meetings?
No,
Okay.
no, it was just a glitch on this one.
All right. Okay, everyone, we're a few minutes out, so we'll get started in a few minutes. We have a lot of people that are logging on right now, so we'll give it a minute before we crank it up. Though I'm sure they'd all like me to get the advertisement part out of the way first. Okay, as all those people, all of you are logging on right now, there's a lot of log-ons right this minute. I'm going to go ahead and start today. I'm Mark Hendrickson, one of the directors of Florida ALHFA. Appreciate everyone who is logging on right now and attending today to our session on ethics and sunshine. Mark Mustian and Mary Helen Farris will be presenting this today, but before we start, Lisa, if you could give the technical advice.
Absolutely. I am your technical assistant for today's webinar. All participants will be muted upon entry. If you look on the bottom, towards the bottom of your screen, you will see a bar with different options. That's where the chat option is, and that's where you can enter your questions. Now, make sure when you have that chat group open, if you want to select and send a message to Mark Hendrickson, you can ask a question anonymously. So for this session especially, if you want to ask a question anonymously, make sure to click where it says to, send it just to Mark, and he is the only one that will get that question. We will have this webinar is being recorded, and it will be available at the Florida ALHFA website. If you're having any audio issues, try logging off and logging back on. You can also send a message to me via the chat box. That's all I have.
Thank you. And again, for those of you that are just looking at your screen, you don't necessarily see at the bottom anything. It's just a black bar. You need to take your cursor and move it down there, and all of a sudden, magically, without even clicking, it'll pop up. So if you do that, there's one that says chat, and you click on that, and it opens up the chat box where you can type questions, again, either to me directly or to everyone. So we definitely welcome the questions. And I want to, again, thank all of our sponsors. They have hung in through this conference when we went virtual. I think it's really great that they did, and they allow us to have this conference for free with no registration costs to our Florida ALHFA members. And I've gone through these multiple times, but thanks to our platinum, gold, silver, bronze, and breakfast sponsors, thanks to all of them for hanging in, and thanks particularly to all of our HFA members who across the board have made this our own conference by sponsoring it ourselves and not just relying on others. I'm broadcasting today from a different location. I was accused of being in a bat cave for the last several, so I wanted to go out and prove I have books also. So I have a bookcase to look professional, kind of. But before we start, again, thanks everybody for joining. Type those questions, and I'm going to turn it over to Mary Helen and Mark.
Thank you so much. Lisa, could you put up the first slide? Okay, the next one, please. Basically, this is the overall statement of the legislature that the ethics code indicates it's the policy of the state that public employees are agents of the people and hold their positions for the benefit of the public. Thus, employees are bound to observe in their official acts the highest standards of ethics, regardless of personal considerations, recognizing that promoting the public interest and maintaining the respect of the people in their government must be a foremost concern. And Lisa, on the next slide, this is the basis for basically all of the ethics provisions that I'm going to go over. It's where, it's a situation in which regard for a private interest tends to lead to a disregard of your public duty or interest. Okay, moving on. The first provision is solicitation or acceptance of gifts. No public officer can accept anything of value or ask for it based on the understanding that the vote or official action will be influenced thereby. This is the actual quid pro quo, where to find a violation, you have to show that there was a meeting of the minds, if you will, that the giver of the gift and the receiver of the gift know that the gift was given to influence the official action. And on the next slide, you can't solicit or accept any financial gifts which is based on the understanding. This is basically the bribery section. And on the next slide, it places the burden on the person, on the public officer, to exercise reasonable care to determine whether a thing has been given with the intent to influence. Basically, one example is if we have somebody in our IT department that is going to be in charge of making a large purchase of computers, and a computer company offers this person Bucks tickets. You gotta weigh that in. Now, in that case, there might not be in that exact understanding, but there's another provision that would entail that. The next slide is doing business with one agency. No employee of an agency acting in his or her official or public official acting in his or her official capacity can either directly or indirectly purchase, rent, or lease any goods or realty at which from his own agency, from a business entity that the official, the spouse, or the child is an officer, partner, or director. This is a status offense, as it's called. There's no waiver here. You can't abstain. It's that you just cannot have that situation.
What does that mean? Mary Helen, does
ahead.
that mean that you just can't be on the board if that's the case? Is that
either can't be on the board, or you just don't do business with from your business with your agency.
Nice.
And Mary Helen, if I can, so my role in this whole thing today is I'm the color commentator for Mary Helen's presentation. But this particular, in my experience, this particular provision, particularly for an HFA board member, is one that comes up most frequently, and that there's a common misperception that, well, I can just abstain and don't have to worry about it. It doesn't work in this context. One of the areas that, as an HFA member, you would see this come up is if your HFA has a program where they give out, subordinate loans to various entities, and your entity wants to apply. In my view, that's doing business, and you can't do it. So I just wanted to bring that up.
Okay, and on the next slide, basically, it says that in this situation, You cannot act officially for your Housing Finance Authority from any goods or services for a business entity. Basically, this is the intersection of your private business and your public agency. The next slide. In this situation, the agency is your Housing Finance Authority, and I have an example. Your partner in a travel agency that makes travel arrangements for, in this case, the Housing Finance Authority. That would be prohibited. On the next slide, city mayor is prohibited from working as a consultant for a waste management company providing services to the city because the mayor would hold a contractual relationship with a business entity which is subject to and doing business with the city. You can skip the next slide, Lisa. And I'm gonna go, everybody has these slides. So this is just all of the elements. And the next slide.
Yeah, if I could, Mary Helen, I forgot to remind everybody that this entire PowerPoint is posted on the Florida Alpha website, and you can access it at any time now if you want it, or later. And this is being recorded, so this session will also be available by Monday on the website.
Yes, and please skip the next slide. And good, there you go. Now, unauthorized compensation. This is kind of like the solicitation of gifts, but in this case, you cannot accept any compensation payment or something of value when you know, or with reasonable care, should know that it was given to influence your vote or your official action. So, you got to ask, why is this person offering me this thing of value? And you don't have to prove direct knowledge. It can be, you can just do implied knowledge on this and be found in violation. So be very careful when people want to give you things. And as I was saying earlier to Mark, being an ethics attorney for so long, nobody offers me anything. I guess they're kind of scared of that. The next slide are some examples. A member city council is not prohibited under the code from accepting a chamber of commerce designation of the councilman's business as an endorsed vendor, as long as such designation is offered absent any understanding or intent that it would influence the official's actions. Another example, of former associate director of facilities planning at Florida Atlantic University was found to have violated the ethics law by soliciting or accepting a personal loan from a company with the understanding that his official actions would be influenced thereby. You can skip the next one, and these are just more examples. Misuse of public position. This is really the main one that you see a lot of ethics complaints. And basically, you cannot corruptly use, or attempt to use, that's when you try to be bad and you fail, anything that you have to secure a special privilege or benefit for yourself or others. The section 104.31 that's cited there has to do with the Hatch Act and coercing people in elections. So it doesn't conflict with that. The next slide defines corruptly with a wrongful intent, and it can be shown with inconsistent with the proper performance of a person's public duties. I have a couple examples of new ones. I couldn't find last year I used the cereal face liquor. Some of you might remember that one, but I do have a few examples, and these are all recent actual Commission on Ethics found that they violated. A clerk of the court was violated the section by using county equipment and materials to reproduce church bulletins. They also violated it by using county issued her cell phone that was issued by the county for personal communications. And more importantly, apparently when people were discovering this, the clerk went in and falsified the clerk's records to try to cover this up, and that was also obviously a violation. There was another one from, I won't say the county, but a female was working and her boss put his hand on her shoulders and leaned in to kiss her and did all kinds of things like that. He said that she basically came on to him, but they found that that was obviously a misuse of public position. Moving on to the next slide. This is conflicting employment or contractual relationship. Basically, a public officer can't have an employment or contractual relationship with any business that's subject to the regulation of or is doing business with their agency. This one does not come up as much, but sometimes you have a fact situation where both doing business with and this provision would be implicated. The next slide,
on this one, Mary Helen, also is there's an exception to this for people that have an employment position with a 501c3 corporation. And
right.
so if, for example, if you're on the HFA board and you're also work for United Way or Habitat or something, and there's something that comes before the board that involves them, you are permitted to, if you abstain, to not run afoul of this provision in that instance. It's specific to 501c3 corporations, so just a state nonprofit corporation doesn't work in that regard.
Right. And on the next slide, there's another exemption that the subsection will not prohibit a public officer from practicing in a particular profession when such practice by persons holding such public office or employment is required or permitted by law or ordinance. The next slide is an example where a member of community redevelopment agency is a partner in a real estate partnership that applies to participate in a low interest loan program. That's kind of what Mark was talking to, because then that would be violating this section. And the next slide is another example.
One thing, Mary Helen, we probably should have said this at the very beginning of this, my number one advice to all HFA members with regard to this stuff is, if you have any questions at all or anything you're worried about, ask your attorney early.
Absolutely.
Because we can then research your specific situation. We can dig into it. We can even call the ethics, folks, hotline and ask about it. But if it just comes up at a meeting, it makes it a lot harder to deal with. So that's the one thing to I hope you come away with this with.
Here, the grant, the governing board of a solid waste authority applies for and receives a grant from a tire grant fund administered by the solid waste authority. That would be another way that this would be violated. The next slide is disclosure of certain information. A public official cannot disclose or use information that's not available to members of the general public. An example of this would be somebody that works in Public Works Department and knows the county's planning in the future to build a certain road, and then goes out and buys land that abuts where the proposed roadway goes to earn a profit on that. So that would be an example of disclosure of certain information. You can skip the next example, and we'll move into voting conflicts of interest. This comes up quite often. And again, as Mark just mentioned, if you ask your attorney and get advice on whether or not you can vote on something, and the attorney says, oh, of course you can vote, and then there's an ethics complaint filed, and the Commission on Ethics will see that the attorney gave the advice that they could vote, they would maybe find that there was a violation of the voting conflicts of interest provision, but they typically will not take any further action. So again, with all of this, please ask your attorney. The voting conflicts of interest, I'll go over a few of the definitions before I get into the actual law. A principal by whom retained means an individual or entity other than an agency, i.e. the HFA, that for compensation, pay, consideration, or other similar thing has permitted or directed another to act for the entity. It includes, next slide, it includes one's own client, employer. Public officer is any person elected or appointed to hold office in any agency. And the term relative is very narrow. It means father, mother, son, daughter, husband, wife, brother, in-laws, and sisters. The next slide. The special private gain or loss means an economic benefit or harm that would inure to the officer, his or her relative, business associate, or principal, unless the measure affects a class that includes the or relatives, but it's a large class. So if it's enough people that are benefiting from this, you don't have the special private gain. On the next slide, and these are all, a few years ago, was added to the actual statute. It used to be the Commission on Ethics opinions had this language, and now it's actually part of the statute.
And Mary
So
Helen,
yeah.
sorry, could I just, as an example, maybe on that last point, or maybe I'm getting, an HFA offers a home ownership program to the general public. And, you know, hundreds of people access it. And one of those people is the son or daughter of an HFA board member who, you know, the general public has access to a program. They also meet the qualifications, have access to it. Is that sort of what you mean by that, that it's of general benefit?
Correct. The size of the class, the nature of the interest, and the degree to which the interests of all the members of the class are affected by the vote.
Okay. So I could vote if I was on a board to have a home ownership program and
Correct.
not worry that somebody might be eligible in my family for it. I mean,
Right. One voting conflict situation I was involved in years ago that actually resulted in an ethics complaint was the county commissioner voted on the land development code to expand where nurseries could go, the plant kind of nursery, and her husband owned a nursery. But it affected basically any business in the county. So that was found not to have been a voting conflict.
Thank you.
Okay, on the next slide, we have the actual law. And it says, no county, municipal, or other local public officer shall vote in an official capacity upon any measure which would inure to his or her private gain, or the private gain of any principal by whom he or she is retained, or the period organization or subsidy of which he or she knows would inure to the special private gain or loss of a relative or business associate. So that's basically what the law says. As you see, it can get quite complicated. And I've drilled into my county commissioners and the folks that I represent that if there's any question at all, please let me know ahead of time so that we can actually determine if there's an actual conflict. Because if there's not a conflict or their parents, the Sunshine Law actually requires that you vote. On the next slide, what do you do? Prior to the vote being taken, you state the nature of your interest. Within 15 days after the vote occurs, you disclose the nature of the interest, and that's a public record. There's a form that you fill out, and the form is filed with the person who's responsible for taking the minutes. And it says also, as being considered for appointment or reappointment, the body shall consider the number and nature of the conflicts previously filed in this section by the officer. That's probably just to determine if it occurs so much, then perhaps another person should be appointed. Some examples on the next slide. The commission found that a county commissioner did not have a voting conflict regarding votes of a county commission concerning a proposed county judicial complex to be located near properties owned by her and her husband's companies. The commission decided here that any gain or loss is remote or speculative. There was no nexus, if you will, between the vote on the sports conflict and any possible benefit that could come to her and her husband's company. On the next slide, a commission member was prohibited from voting on a proposed ordinance prohibiting billboards where the commission member owned several billboards within the city. The measure would inure to the commissioner's special private gain or loss, and he would be required to disclose the nature of his interest and abstain. Some more examples. No conflict was created where a mayor voted on matters relating to the de-annexation from the town's boundaries, part of a subdivision where he resides, because the number of lots in the subdivision that could be de-annexed was significant, 108 lots, and their de-annexation would affect all of them proportionally equal manner, such that there is no special gain or loss to the mayor. Further example, a council member was not prohibited from voting on the city's ratification of collective bargaining agreement or amendments to the city's ordinance regarding changes to health insurance that he and other union members receive under the collective bargaining agreement. The number, again, of receiving the retirement benefits was sufficiently large that the benefit to the city commissioner would not be special. Finally, as we said before, always ask, I say here, the county attorney's office, your HFA counsel. Then again, if probably no action will be taken against that official in case a complaint is filed. So like I say, you can blame the lawyer. Moving on, and Mark, are there any questions so far?
Well, I've got a few that, I'm again, encourage people to type in, but knowing that so far it's not happened a lot. I have a few that on this for both you and Mark about some of these conflict ones. Who's responsible for knowing the law, the gift giver or the gift receiver?
I would say both.
Yeah,
Just because somebody gives you something doesn't mean that it's okay to accept it. If you sometimes misuse a public position or the bribery solicitation of gifts could amount to some kind of fraudulent activity. So it's both should know what the law says. And Mark, I don't know if you have any more input into that.
No, if somebody offers you football tickets, say no on that. But yeah, I think that this is modified some over the years, but I think people generally understand now. I mean, anything other than a trinket is problematic.
How about that dinner at the Florida Alpha conference that's part of the conference itself? And is that okay?
Yeah, because that's paid for.
Yeah.
In your registration fee, so that wouldn't be a gift. And one other thing, you just have to be really careful with receiving gifts, and especially because the HFAs deal with such large amounts of money, and it's just sometimes the spotlight is on the HFAs, and it's just important to be above board on those types of issues.
What's a couple of more questions, if it's okay? Can I
Sure,
just keep
absolutely.
firing some of these ones? If a HFA board member works for a bank that buys bonds on a private placement basis or is a credit enhancer for deals that come before the HFA, is that a prohibited conflict or a voting conflict?
Depending on, and I'll let Mark chime in too, depending on the factual basis, it could be, but for the voting conflict, you really have to have a direct special gain or loss. And if it's something that's large, that there's not really that nexus there, then it may not be a voting conflict.
So like if you're not that there are bank tellers on HFA boards, but if you're a bank teller in the Pensacola office of Regions Bank, the fact that Regions Bank may be involved in the bond business in general is probably not going to go to your personal gain.
That's correct.
But if you work in the municipal finance area of Regions Bank, that might trigger a problem. And
Right. And these are so very fact specific that it's, really, again, get your lawyer involved so that all the facts can be looked at. And, from time to time, I reach out to Chris Anderson at the Commission on Ethics and, just bounce things off of him as well. But they're very accessible.
One other thing on voting conflicts, and just I say this as a former elected official, that it could come up some with HFA members as well. I mean, one of the more difficult parts of that is, when a personal friend offers to do something for you, that, hey, use my condo at the beach. And, where otherwise you wouldn't really think twice about it. I think you have to think about, hey, I'm a public official. Could anybody construe this as this is a gift, that they're, and so I think you have to be extra cautious just, if you're, because you're in this position.
okay. A couple more questions. I'm going to just roll with them for a minute.
That's fine. Yes.
let's say that a company already does business with an HFA. Let's say the Nabors law firm is our bond counsel, and I'm the administrator of the Leon County HFA. They're not our bond counsel, but I, just making this up. And Mark at the Nabors firm decides that he'd like to hire my son or daughter to work at the Nabors firm. So at that point, I'm not voting on whether or not we're going to hire them, but at some point after they're hired, they hire one of my relatives. What's the play on that?
Well, if there's no nexus or understanding, or you can show that the person should have known that that was done to influence them, then it may not be a problem. Mark, do you have any other?
No, I mean, I think it's something you'd want to be pretty careful about whether it now, now that they've, hired this person, are they doing business with the agency? I mean, if you're an employee of the agency, it may be okay, but I think that's one you run by your lawyer, hopefully, before you do that. Okay.
If somebody offers an HFA board member a meal or a golf outing, can they ever take it, or is there a dollar limit? What's the trigger, or is it always a problem if it seems to be trying to influence a decision?
Well, if you've got the facts that it could be, say it's a developer that says, hey, HFA board member, I want to treat you to a round of golf at this very exclusive golf club, then you would have a problem there, because the appearance and, reasonably, why was that given to him? That there may be no other reason but to influence his official action.
Well, and the round of golf probably exceeds the limits dollar-wise. I mean, a meal maybe, but I think it gets back to what Mary Helen just said earlier. I mean, what is the intent of this? I mean, why is somebody doing this? And so it's sort of specific in that regard.
Right.
Are there any of these things that are actually cross into the criminal code versus just the ethics and fines?
It could, given this, whatever the state of facts. And typically, if there is an ethics complaint, and then subsequently there is either FDLE or state attorney's investigation or something of that nature, the Commission on Ethics will typically hold off until that is resolved. But it could be that you violated the ethics code and might get fined, as well as having either civil or criminal liability as well.
Okay, thanks. I'll turn it back over to you, Mary Helen, to move into the
Okay. Sunshine. We've really made some inroads in Hillsborough County with holding our Board of County Commissioners meeting virtually because of the pandemic. We have a fairly good system. We use WebEx, which is similar to Zoom. And the way we handle public comment is the notices are very detailed. They give the public a link to sign up. They have to provide their name and their phone number. And we close that 30 minutes before the meeting begins. And then when it comes time for public comment, our IT person, our chair, will call on Joe Brown, and the IT person unmutes Joe. He says what he needs to say for the 3 minutes, and then he's muted again, and we go on to the next one. And it's really starting to catch on. And I think that, depending on how long we have to do these virtual meetings, you might get more public participation because they don't have to get dressed, come downtown, find a parking space. They can just sit in their pajamas and participate in the meetings. So we're actually going to do our first land use meetings. We're going to do a hybrid that's both virtual and in person, but it's extremely hard to meet all the COVID guidelines when you're having folks come in. But basically, let's go over what is sunshine. All meetings of any board or commission at which official acts are to be taken are public meetings at all times, and the board or commission must provide reasonable notice. And I'll go through each of these. The next slide, Florida, next slide, please. There we go. Florida leads the nation in its open government laws, both by the way the statutes are written, and it's also in our Constitution, and by the way the courts have interpreted it. So the tendency is to err on the side of that it is subject to the Sunshine Law. And on the next slide, what is a meeting? Obviously, your HFA board meetings are subject to the Sunshine Law, but it's more broad than that. Basically, any gathering of 2 or more members of the same board that discuss something that reasonably, foreseeably will be something that they will take action on has to be only communicated at an open meeting in adherence with the Sunshine Law. It doesn't require a quorum, any gathering, formal or casual. So it's the important thing here is 2 members of the same board and discussing a matter that might reasonably go back for them for action. So if 2 members of the HFA want to talk about the Tampa Bay Buccaneers and Tom Brady, for instance, and that has nothing to do with anything that might come back before them for action, would not be violative. But be very careful of the slippery slope. I always have some angst if I see, 2 board members or 2 commissioners talking to each other. I think I've drilled it into their heads deep enough that they're not going to talk about something that might come back before the board. Now, obviously, the Board of County Commissioners has a much wider range of issues that would come to them than something that's a little bit more, that's much more narrow, like the Housing Finance Authority.
Yeah,
And the next
couple of
slide.
things,
Oh, go ahead.
things on this, Mary Helen. So one is, we get a lot of questions. Well, can I have lunch with another board member? Well, yes, if you don't discuss anything that might come before the HFA. What I generally advise people is, that's sort of to be avoided. It's not again, as long as you comply with that, you're complying with the law. But if you're setting like a weekly lunch, then it starts to look like to people from the outside that, well, how could no HFA business, ever come up in the conversation? So I think it's just to be avoided, something like that. The other thing,
Absolutely.
and it may come up less in this context, but it could. So the other thing that you're not permitted to do by the Sunshine Law is use somebody else as an intermediary to communicate. So for instance, let's say Mark Hendrickson is the FA for your HFA, and I'm on the board, and I asked Mark, so, well, where's board member Andrews on this? And that's communicating, indirectly, and you're not permitted to do that either.
Right, and there's a case on that. It was actually a school district in Central Florida that they were going to decide on very controversial redistricting their school boundaries, and the supervisor went from one school board member to the next, to the next, to the next. The court said in rapid succession, and basically then when they entered into the meeting, and all the parents were there, they just took a vote on a certain district map. And that was found to be violative of the Sunshine Law for the very reason that Mark said. They used the liaison intentionally as a go-between to kind of broker the deal, if you will, outside of the Sunshine. Is there any more questions?
Well, yeah, there is, and there's also another question back on the other topic, but I think I'll hold it till later. We do have some executive directors and administrators on the line here, as well as board members. So a good administrator, a good executive director has a pretty good feel in advance of a meeting where he or she board members stand. In other words, you'd be pretty stupid to be a director and walk blind into meetings, not having any idea what your governing body thinks. So what's the balance between that, kind of gleaning for yourself so you can do good staff work versus the being the telephone tag person that in effect kind of moves from board member to board member as an intermediary.
I think in this case of the liaison or the intermediary, there is an intent on the part of the parties that, the deal is being brokered. In my county, the county attorney and the county administrator meet with all 7 of our commissioners individually, and each one does, and just to get the feedback and questions of that nature. But they know not to say, Commissioner A really wants this program to go forward, and if you can get Commissioner B to back me up, I'll vote for Commissioner B's idea on a new park type of thing. So there's an intent there to use one person as an intermediary.
Yeah, it would seem to me that happens most, not that it ever happens, but it would be a danger of that happening when you get to items like, who do you think got to be the next chair of a board, where people are reluctant to have that kind of a discussion, just not out of nefariousness, but just they don't want to be embarrassing to people.
Right.
On a thing, but okay. And do you mind if I jump back to a question on the pre-sunshine real quick? So I don't.
No.
It's one that came in from the audience, and it's if an HFA member is also a member of another nonprofit board, what do they do when not like funding issues, but issues in general come up before the HFA that are related to that nonprofit? I mean, again, as separate from making a funding decision, a policy
Right.
issue, a discussion. Yeah.
Well, as I said, the Sunshine Law prohibits 2 members of the same board from discussing an issue that might come back to that board. So for instance, if a county commissioner and a city council person wanted to have discussions about local government business, that would not be prohibited. I always caution, though, that we have Aviation Authority, our Metropolitan Planning Organization, our HART Board, that's the Bus Transit Authority, where you have city council members and county commissioners that serve on that board together. So therefore, they could not have any conversations about transportation issues that might come back to that board that they serve on together. So it really requires 2 members of the same board. And not sure if I answered the question.
Well, that was part, and the other is there back on the sunshine? Is that is it a conflict where they're on, a nonprofit that subjects that impact the nonprofit, not directly, but through policy, come before
Right.
the HFA?
Well, there might be a commonality of subject, but I don't see a conflict just in the facts that you stated.
But we would, that was one of those, Mark, I think you'd say, talk to your lawyer on that one.
Yeah, absolutely.
Yeah, and the other thing, I always, again, as a former elected official, I always figured that, the more disclosure, the better. So even if if it's legal, I always thought it was helpful to make sure your other board members know, said, hey, I serve on this, nonprofit, here's what, blah, 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 just so people sort of know where you're coming from. But I think in the context you describe, it's probably okay from a legal standpoint.
Okay, thanks. And if I could real quickly, just so we get all our records right, there was a technical glitch when I sent out the invite to this meeting, so that a lot of people that when they registered, their name is showing on the screen as Lisa Jahed, who is our technical advisor, and there's still a couple of people who have their name showing in front of their picture that way. And if it's our mistake, we apologize. But if you could, just for our records, if you could go and change the name to your name. And again, you do that by taking your cursor over your picture, moving it to the upper right-hand corner. There's a blue square with 3 little dots. You click on that, and one of the options that come up is rename. Hit that and type in your name. Thank you. And I'll turn it back to you, Mary Ellen, after that brief technical interruption.
Okay. What is the scope of the Sunshine Law? The 3 basic requirements. They have to be open to the public. reasonable notice must be given, and written minutes must be taken. A lot of boards and councils that I represent typically will record the meeting, which is fine, but the statute actually requires written minutes. On the next slide, what is also subject to the Sunshine Law, public collegial bodies, elected or appointed boards or commissions. If a public officer is delegated authority to act on behalf of the board, that could maybe trigger the Sunshine Law. Federal agencies are not subject, and also the legislature that wrote the law is not bound by the law. I find that interesting. On the next slide, when a board subject to the Sunshine Law, any group that narrows the issue for the board's consideration, even if the recommendations are not binding, private entities, when created by or delegated functions by the public agency, staff standing in the shoes of public officials. It's the nature of the act performed, not the makeup of the committee that would be subject to the Sunshine Law. On the next slide is the exemptions. If a committee is established for fact-finding only or merely informational, I read the Sunshine Law very broadly, and rarely do I see that it's actually for fact-finding only. For instance, if 3 members of the HFA wanted to go tour something or go visit something, it's really easy to slip down the slope of not just fact-finding, but actually talking about substantive issues. And that's on the next slide.
Mary Helen, that is one that HFAs face all the time. They finance a development. The development's having a grand opening, and there's all kinds of people there, and maybe multiple HFA members are in the crowd or are even speaking. Is that okay to go to a grand opening?
Yeah, as long as they don't talk amongst themselves about something that might come back for them for action. In the case of a grand opening, most of the decisions probably have already been made, but there may be an issue that comes back to the board for action. So, just keep it a social event and not talk about HFA matters that might come back to the board.
So they shouldn't say to each other privately, hey, this place really looks crappy. Let's not fund this guy ever again.
That would be a no-no. Okay, on the next slide. What else is subject? Phone calls, letters, a single member delegated with authority. The biggest issue right now in Sunshine Law, and also with public records, and I'd like to point out some before we close, is the use of social media. We have public officials that have private Facebooks, and if they put up a post that I'm going to oppose any increases in the rate of our water rates, and then another commissioner posts, well, I agree with you and I support you on that, you could have the quote unquote discussion. So it's very important, and with text messages and LinkedIn and all of these social platforms, you have to be very careful that you don't have the actual discussion between 2 members of the same board. Yeah, go ahead.
Mary Helen, this came up at Florida Housing Finance Corp a few years ago, where one of their board members wrote a letter to all the other board members and said, I think we ought to be doing X, Y, and Z. And they all went into panic mode, but their attorney said, hey, everybody just don't respond. Nobody
Correct. Respond,
and you probably are, we wish you wouldn't have done it, but it as long as no one responds, it's okay. Was that?
That's correct. Years ago, we had a county commissioner that would fax out his white paper or whatever you want to call it, where he says, I support this, I don't support that. And as long as there's no response back, there's no violation of the Sunshine Law. So it's kind of like, be the first one to put that out there, and then nobody else can respond to it. But it's just one-way communication is not a violation. But best practices, and Mark, you use this, is if you're going to send an email out to the board members, You can say don't hit reply all, but the better thing to do is just blind copy the board members and send it to yourself. And that way they can't unintentionally hit reply all and maybe have a possible violation. You can skip the next slide. And yes, when does it apply? Upon election or appointment. And this is important because if you get a new HFA board member that's appointed, and it might be a month or so before the first meeting, and they may unintentionally just reach out to the other board members to say, you know, what are the hot issues? Where do you stand on these issues? You know, what are your future plans for the votes, the way the HFA should go? That could be a problem. So it's my practice to reach out to new members, whether it be a county commissioner or HFA member or any other board or council, to make sure that they understand that as soon as they're appointed, the Sunshine Law applies to them. And also as soon as they're elected, even if they have not been sworn into office.
So Mary Helen, again, I'm just, you know, these are practical things too. So if HFA board knows that Mary Helen Farris and Mark Mustian are being considered by the Board of County Commissioners to be appointed to the board, but they haven't been appointed yet. The existing board members, it would be okay for them to talk to Mary Helen and Mark to find out, hey, do these people know anything about housing or not? Or to just share, you know, what the board's up to. Say I apply for the board, I haven't been appointed. I want to call up Mark, who's on the board, and say, hey, Mark, could you give me a briefing? It's okay up to the time I'm appointed by the Board of County Commissioners, but not the minute
Correct.
I'm appointed, it isn't.
That's
Right.
correct.
Okay.
Right. Up until the point of appointment or election.
Thanks.
The next slide, we already spoke about members of different boards. It has to be two members of the same board, but again, you know, with the caveat that if a county commissioner or city council serve on a different board, then the Sunshine Law rules would apply. The next slide, ex officio members are subject to the same requirements as the voting members. On the next slide, social events. There's nothing prohibiting. I mean, obviously this year the conference is different, but there's a lot of interaction among board members with other board members at, you know, the conference, and it's okay as long as they don't talk about any business that's coming before the board. But I'll tell you, like Mark said, I tell commissioners, I say, you know, don't go to lunch all the time. Even so far as during a board meeting, when I have one commissioner lean over and whisper something to another commissioner, and immediately the media comes up to me and says, violation, violation. And I say, no, not necessarily. If they're just talking about, you know, the air conditioner is not working or something, that's not a problem. But I tell my board, you know, don't create that. And more recently, in recent years, you see one pick up their cell phone and another one pick up a cell phone. And it's like, you know, who are they texting? We now require our everybody from the department directors up, including the commissioners, have a county cell phone, and every text and every email that goes to that phone is automatically archived.
Hey, Mary Helen, just on that topic real quick, because I mean, it probably comes up less for HFA members, but if you have a personal cell phone and you text a fellow board member, I mean, that's a public record, right?
Yeah, if it has to do with official business, it doesn't matter if it's a private or public, correct?
Yes, and so, you know, I guess, you know, as a board member, you probably ought to think about if there's litigation and somebody says, you know, public records request for every, you know, I mean, that would include potentially some of your personal texts on your personal phone if they you know, relate to the HFA.
Right. Okay, the next slide has to do with bus trips or tours. My board did this a long time ago. They wanted to go see the resource recovery facility. So what we did is we noticed it. We had vans that would accommodate the media and the interested public. So we complied with the Sunshine Law. But I haven't had that come up in probably 20 years. It's really been a long time since that came up. Next slide. Okay, and the next slide. And this is notice, and it says reasonable notice must be required. People hate it when the lawyer says reasonable because it could mean anything. Typically, it's at least 24-hour notice. For certain entities like the ALHFA, there might be other notice requirements in the statute. So it's not just under the Sunshine Law, but there's other authorities for it. My extreme example that I always give, I was pulling into the building on September 11th and had heard on the radio about a plane hitting the World Trade Center. At the time, I thought it was like a Cessna. And as soon as I got to my floor, the county attorney called me down and said, the board needs to meet in 15 minutes. Is that reasonable? Under the circumstances, yes. The board met, the sheriff was there, the clerk, because they were deciding whether or not to close the building down, which they eventually did. That's an extreme example, but it just has to be reasonable notice that's required. Next slide.
That wouldn't be like, okay, if we said, oh, we just forgot to hire our trustee, we're going to give 10 minutes notice and have a board meeting because we forgot to do something.
That's correct.
Yeah.
That is absolutely correct. I think that would be a problem with the notice. Agenda is not required. There was a bill that went through several sessions ago that would restrict Sunshine Law boards from, they could only discuss things that were on the agenda. Luckily, that did not go anywhere. At our board's meetings, we have public comment. It's the longest 3 minutes in the world. But people come up with things and the board needs to react to those. So you can't act on things that are not on the agenda. But it really, you have to be just careful. You wouldn't want to talk about something of big import that's not on the agenda because you could have, due process problems or something of that nature. With that, I'm going to, first of all, are there any more questions on Sunshine Law? Because I'd like to jump really quickly to some public records.
No, there are no questions pending.
Okay. I didn't, I haven't had time really to do my public records presentation. My ALHFA doesn't really get a whole lot. We've gotten some that were just, Mark, as you know, huge public records requests that had to do with litigation. But basically, the things that often come up, if you make notes during an ALHFA meeting that are your own personal notes, you don't share them with anybody, they're not to be permanently filed anywhere, those would not be a public record. Again, ask your lawyer. You have to respond in a reasonable amount of time. You have to acknowledge it. We have a very sophisticated system that we use where citizens can just go through what we call a portal and put in public records requests, and then we track them. Everything's, we have it, the Citizen Request Manager, CRM is what we call it. So at any point in time, we can go in any public records request and know when we received it, who we sent it out to on staff, what records we retrieved, and when we responded to the requester. But if I have just a few minutes, I'd like to read some actual public records requests that my office received. I just think do this at the end for a little humor. The first one, animal attack. That's all they said. The next one, house arrest. I would like to get a public record of myself. I received check in my mother's name and I need to be able to cash them. Want to know about my records. One said 21-year-old female. I don't know if they're actually looking for a date or what they actually wanted. One of my favorites is looking to find my marriage license and divorce record. Not sure of the year and only remember guy's name was Tim. That intrigued me a lot. Actually, it was somebody that lived in Minnesota, and I really had to stop myself from calling and saying, you got married and you got divorced. You don't know what year, and all you guys, is his first name. I just thought that was hysterical. And I'll end with this one. Need to check criminal records on Jocelyn White. She is my girlfriend, and I'm trying to figure out if she's the right one for me. Please follow up with me. Thank you. Well, this poor guy sets the bar so low that as long as his girlfriend can pass a criminal background check, I think that she would be the right one for him. Yeah, so I just wanted to share some of these. I sometimes, they're very hysterical. A lot of times it's just folks really don't know the right way to ask for records. So we always reach out to them and say, what is it really that you're looking for so that we can respond.
Thank you. And Mark, you have just a couple of things to cover. If you could, Lisa, move to the next slide.
Yeah, so there was a bill that passed this session of the legislature that was signed into law by the governor that has a few things that are related to HFA members. And it's sort of, I think, some clarification that there are, there's some exceptions that we covered earlier in the ethics code that this, just makes sure that they also apply to members of special districts, which HFAs are generally a special district. So yeah, we talked about that if you're practicing in a particular profession that's required by the law, which it is for HFAs, that doesn't necessarily kick you off the HFA for doing business. And then the 501c3 exception that I mentioned before would also come into play. And same thing with exceptions for voting conflicts. There also is a provision in this statute that this may be on another slide or
Next
not,
slide, yeah.
about in terms of the reports that HFAs are required to give, that your audit report, once you give it to the Auditor General, that suffices. And then the district's agenda, we talked about agendas a little bit ago, is generally required to be made available 7 days prior to the workshop. So generally you're working in a 7-day notice period for a meeting. There used to be a requirement that all agenda materials had to be attached to your notice, and that's been deleted. So it's just the agenda now, but that's something to bear in mind as well.
Mark, what's the effective date of that last bullet, the one on, because I know that's been a major problem for HFAs, that we have to publish every document that we're going to hand to a board member has to go on the website along with the agenda 7 days in advance. That's been a problem. So when does that requirement go away?
I believe the entire act is effective January 1 of next year. So I don't think it's in effect yet.
Yeah, that was mine. So I think, so we're still stuck for the rest of the year with putting all the materials, but as of January 2021, we'll be good to go on board meetings by just doing the agenda. That's,
Yes.
again, everybody should consult their own counsel on this.
No, and I would echo what Mary Helen said earlier, because sometimes there's misconception about this. I mean, you don't have to have, at least from a legal standpoint, something on the agenda to take a vote on it. I mean, a lot of times it's not necessarily advisable to do that. You want to give the public a notice of what you're dealing with, but there's nothing that legally prohibits it. If something comes up that just needs to be acted on, you're not prohibited from acting on it, even if it's not on the agenda.
Good. Well, we're basically hit right on the nose of 1 o'clock. No one actually confessed to any crimes on the chat, so that was probably a good idea. But we do encourage everybody that's on HFA board or staff, if anything comes up that is even remotely questionable, or you worry that if somebody looks at it, they might think that it's questionable, talk to your HFA counsel, and preferably talk to them before you get into a board meeting. That would be very helpful. And I want to thank Mary Helen and Mark for that session. If anybody thinks of a question afterwards, feel free to fire it on to us or to ask your own counsel. And I want to put out a reminder that we have 2 sessions next week. On Tuesday, we have was sort of a 101 of housing programs. It's not the old bonds 101, because what HFAs do are way beyond bonds at this point. It's much broader. And on Friday, we have the release of the 2020 HFA journal with all the stories of what HFAs around the state are doing outside of just doing bonds. So those 2 are next week, and I'll be sending out the invite to both those sessions this afternoon. Thanks again to everybody for joining. And some people actually liked your presentation, and they will they're posting that. So kudos to you guys. Thanks everyone, and we'll see everybody next week. Thank you.
Okay, take care.
Thanks everybody. Bye-bye.